SJC-12712, Ellen H. Davis v. Gina Comerford and another.
Is it Mr. Hardy Doubleday?
Mr. Hardy Doubleday, yes.
Okay, that's it's fitting in with the baseball theme for today. so-
Right, right. May it please the court, my name is Attorney Arthur Hardy Doubleday. I represent the appellants, the Comerfords in this case. We're here to answer two very important questions in Massachusetts housing law. One, does the housing court have the authority to enter use and occupancy orders prior to a final judgment? And then two, if so, under what standard? My answer to question number one is presently there's no statutory authority for the housing authority to enter pre-judgment use and occupancy orders. If you look at 239-8A, you will see that the housing court can enter a use and occupancy order after the case has been heard. Explicit words in that statute. To me, after the case...
You're saying that that statute suggests then that it intended that they not be permitted to do this before, that it's kind of a block.
Correct, correct. 239, subsection 5, on appeal, a use and occupancy order can be entered. And then Mass General Law 11, subsection 27F.
Sorry, what was that one?
I'm sorry.
What was the statutory reference? It was what?
Mass General Law 111, 27F. In that particular circumstance, that applies to tenants who are trying to get a repair done. They've petitioned the court to force the landlord to make a repair. And explicitly, it says if he referring to the tenant, is in arrears and is willing to pay any arrearage into the court as ordered. And in that particular case as well, it's to the clerk of the courts, not directly to the landlord.
But can I ask then, so if the tenant has a problem with the building and isn't paying, you can order it. But your client doesn't have a problem with, right? There's no warranty of habitability issue here, right? We don't have rats or mice or anything. We have someone who's not paying and they're trying to evict. Don't they have to pay? You don't get to live rent-free. I'm confused. I understand if there's a warranty of habitability issue because you're fighting over whether you're getting what you're supposed to pay for. But if you're just not paying and you're asking for more time to stay, don't you have to have a right to get, doesn't the landlord have to have a right to get paid?
Well, if you look at the record of this case, the tenants filed an answer with a number of counterclaims, including breach of warranty of habitability, breach of quiet enjoyment, 186.15b violation, 93A violation.
Okay, so then you fit within that category, but it seems like your argument would extend even when there's no question you owe the money and the landlord is providing a suitable domicile, right?
Well, let's assume.
I'd just like to understand, because it seems complicated. Would you say the same rule applies for a landlord who's done a good job and the place is fine, it's just they're not paying? You couldn't order use and occupancy?
Well, if you look at 185C, subsection 3, there is the power of the court. The housing court does have equitable remedies, and it can issue preliminary injunctions. And if there were to be a basis for a use and occupancy order to go in, it would be under that power. And under that statute, we're looking at injunctive relief.
Okay, but can you just answer my question? Someone's not paying, the summary process is going on, and the landlord landlord's done everything they're supposed to do. Is it your view they can't, unless they meet this irreparable harm standard, get paid?
Correct.
Why?
Well, it's on the landlord to show the court. I mean,
Landlord's entitled to get rent if it's not doing something wrong, right?
right, but they can easily show that to the court if they come in.
Not under the irreparable standard, harm standard you're proposing, because money damage is almost never irreparable harm. So why wouldn't they be entitled to get paid if they're not doing anything wrong?
Well, I think that's a question for the legislature.
So you think that the legislature intended some small landlord who's got 2 units in their building, who's done everything right and not getting paid, to have no right to use and occupancy unless it establishes irreparable harm?
Correct.
Okay.
Mr. Hardy Doubleday, do you agree within the equitable powers of the housing court that they could order payment of what the rent would be to the court to go into counsel's IOLTA account?
Yes, if they focus through the lens of a preliminary injunction, that there be almost a mini trial on what's going on, the facts in this case, and the law applied to it.
How's the tenant going to be able to stay in the dwelling if the landlord can't pay the mortgage, pay the taxes, and has to lose his or her house, or lose the 3-decker? Is that okay? I mean, then they have to leave, right? Because they're not getting rent, and they're not going to be able to maintain the mortgage payment.
Well,
Then what happens to the tenant?
well, conceivably, the house would go, the apartment would go into receivership, and someone would be in charge of making those repairs.
So that the tenant can live there, the owner just gets foreclosed upon.
Well, I would think that if the owner were going into foreclosure, and the title to his property were to be taken away, that would be irreparable harm.
What if they're not going to go into foreclosure, but they just can't pay for the groceries? Can the tenant still stay there for free?
I think that's something that the trial court judge should decide. What is irreparable harm in every particular circumstance? But what you can't have.
What's the mini trial look like?
You would basically have the landlord testify as to the state of the apartment and the rent ledger, and if need be, the tenant could testify as to what are the conditions, and if need be, pull in ISD or the Board of Health, wherever they might be, so that the court can make a finding of what the fair market value of the apartment is. A lot of housing court judges just determine the fair market value based on the last rent payment made or whatever the lease says. But that might not be the case. If your apartment is infested with rodents and has been for 3 months, is the fair market value $3,500? I would argue no. So there needs to be some evidentiary evidence for the judge to make a determination as to what the fair market value is there irreparable harm, and if there is, then okay. If not, no.
But don't you,
I'm sorry, I'm still trying to reconcile the irreparable harm and money damages issue, and how you can ever get there with irreparable harm.
Well, I think that if the landlord can show that they are going to lose title to their property, that would be irreparable harm. So if the landlord can show that the reserves are gone, they can come in and ask for an injunction, and the judge can make a determination whether it's appropriate here or not.
Anything else that would come to mind as well that would be irreparable harm?
Well, it would be a balancing test between what's going on with the tenants.
Because judges read irreparable harm inequity, and they usually, the old saw is money damages, right? So I'm just trying to, if we were to rule your way, we try to give guidance to judges with this rule, what should we tell them regarding categories of irreparable harm? You gave me one, loss of titles. Can you think of anything else?
Well, I think that they should also look at what paying use and occupancy would do to the tenants, especially in a situation where there's ongoing violations of the state sanitary code, and what irreparable harm that would have on the tenants. In a lot of ways in housing court, when these use and occupancy motions go into place, the tenant is forced to answer one question: how important is my home to me? Because at that point, especially in a situation where the apartment's in disrepair, the judge has ordered the tenant to pay full use and occupancy regardless of the conditions.
Right. I understand that concern, but let me see if I can see what your world would look like. So there's a eviction action. Upon the notice to quit, the tenancy lawfully is terminated, and pending the adjudication of the case, the tenant is a tenant at sufferance, correct?
Correct.
Okay, so by continuing to live there, the landlord would have at least entitlement to quantum merit, the fair value of the premises for which he or she would be entitled. So there would be, and you say the quantum merit value may not be the actual rent because the property may be diminished in value by rodents or other things. So you would say the judge would have to determine then what the quantum merit, what the fair value is.
Correct.
Then you get to the issue, and the landlord would be entitled to the quantum merit because the person is living there and deriving some value. And the question is irreparable harm. So is it enough to say, for the landlord to say, listen, there's no way I'm going to get this money if upon the eviction, what am I going to do? I'm going to file suit?
No, that's not enough.
So what would be irreparable harm to a landlord when in the real world, if that money is not going to be paid monthly, it's not going to be paid? Let's assume the person seeks a jury trial, entitled to. It's going to be, it's going to be 3 months, 4 months. Is he entitled to 4 months of free rent, or how is that? How is that supposed to work?
Well, the issue here is that the tenants have invoked their rights to a jury trial. They've invoked their rights to have a jury of their peers make a decision on whether their counterclaims are worthy of a judgment in their favor. If you want to be a landlord in Massachusetts, you have to deal with that. And to have a situation where landlords come in and file motions without affidavits, without showing any type of harm, you're taking away some of the rights that these tenants have, which is to be adjudicated, to have a jury or to have a judge make a determination as to what is actually going on here. And if you apply the injunctive relief standard, at least there will be a trial, a mini trial, that will show to both sides what's actually going on, what's materious. And if there is irreparable harm being exacted on the landlord, by the landlord not getting this rent, then the judge can make that determination and make a use and occupancy order. Notice that this isn't a use and occupancy order where it's going into the clerk of the courts or it's going into my brother or my IELTS account. This is going directly to the landlord. The landlord is getting the benefit of this order, whereas the tenants...
Because otherwise he's or she is getting nothing, right? Under your proposal, it's you win in each respect, because there's always going to be irreparable harm on the tenant if they're forced to leave the building, right? And if they lose the notice to quit, they're not going to pay the back amounts, are they? The landlord's either going to is going to lose all this money even if they win.
That's not necessarily true, because what are we talking about? We're talking about a tenant's home, while the landlord owns it.
It's the landlord's it's the landlord's home and the tenant's rental. So both people have an interest, and isn't the use and occupancy, particularly if the amount is set to take into account warranty of habitability problems, appropriate? It just, otherwise the landlord gets no money and you live rent-free. It just doesn't seem fair.
Well, 239-8A builds in a runway, and it says if the tenants win, then the tenants have a certain amount of time to pay what's in arrears, otherwise the judgment goes in favor of the landlord.
But they don't get paid, right?
That's not true.
So so when the landlord wins, say your tenant, I understand your tenant may be completely in the right, but say your tenant isn't. Say your tenant just isn't paying and loses and has no money. How does the landlord get compensated for the fact that that landlord had no one living in there and is making no money and your client lived for free?
I believe that we deal with that in supplemental process.
How? In the real world?
The landlord can have the tenant summons to court, and the tenant can explain to a judge why he or she can't make payments on this judgment that's owed.
I sat in the supplementary process, supplementary process on Mondays in the Lynn District Court for 4 years. Not going to work. Let me ask you what I think might be an easier question, though, because what you're saying, I understand what you're saying. You're saying that, wait a minute, I've got a legitimate counterclaim here, and the value of my tenancy is not the amount of the rent, and that's not fair, that I'm paying not to the lawyer, not to the court, but to the landlord, this amount of rent that isn't the value of my tenancy. So I understand what you're saying. I get your point, and it's a point that needs to be taken into account and taken seriously. But let me ask you just how far this goes. Okay, so let's say it's a notice to quit, non-payment of rent, and there's no counterclaim, there's no security deposit contention. Because of whatever reason, counsel, schedule, whatever, the trial's not going to be for a month and a half. Can the housing court judge, as part of his or her equitable powers, order use and occupancy in that situation?
I would argue that it's on the landlord to ask to make a motion with an affidavit showing evidence of the fact that no rent's being paid, that there are no counterclaims, go through the standard laid out in injunctive relief. Now, if the landlord isn't going into foreclosure or isn't having something drastic happen to him as a result of this case, then no, we're having a trial in a month and a half. You will have your judgment, and you can move on with your life after that.
All right, because the landlord in that situation, even if, I understand you're saying no, they can't, but as far as the first part of your answer, if you've got the affidavit, you've got the notice to quit, and you have the documentation, and you come in and you say to the housing court judge, I'm looking for an injunction for use and occupancy, the judge is going to say, well, it's money damages. I mean, you got to balance irreparable harm. Money damages is usually not irreparable harm against the tenant's situation. So I'm not sure that the injunction's going to work in that.
It's not.
All right.
It's not, and it shouldn't.
Okay, thank you.
Thank you.
Mr. Gormley.
May it please the court, I'm attorney David Gormley from Brockton. I think it would be of great assistance if I gave you a little bit of the factual background on this case, if I may. I represent the landlord, Alan Davis. This is a single-family house in the city of Brockton. The tenants moved in 2014 Shortly after they moved in, they also rented the garage, so they're renting a single-family house with garage in the city of Brockton. And they were always on very good terms. And in the summer of 2017, Mr. Davis told the tenants, "I'm going to sell the property. Would you please think about moving out? Would you please move out? Would you please move out?" And each month that went by, the tenant said, "Yeah, we're trying to move out. We are looking for a place. We can't find a place." Months went by, more months went by. And finally, in May of 2018, the tenants notified the landlord that they wanted him to apply the security deposit for the rent of the month of May. That's usually a very good sign. They applied it, but there was a shortfall of $612 because each year the rent went up a little bit and the garage was now included. So when they never made up the shortfall in the month of May. So Mr. Davis consulted with counsel, and we served a 14-day notice to quit for failure to pay rent. When June came around, no rent was received for the month of June. The summary process complaint was served because the 14 days had already passed. Then a check was tendered by the tenants, deposited and dishonored by the bank twice. So the addendum on the original complaint is correct. It's $612 for May plus the month of June. The tenants did not move out. They retained counsel, my able brother. Counsel filed discovery, which automatically continues the case 2 weeks in order for the landlord to answer that discovery. So the first time the case went before the court in Southeast Housing Court was July 11th. On July 11th, Judge Edwards had a short hearing. He heard from both counsel, the parties, and he made a 3-part order. He ordered that the tenants pay the rent for the month of July by the 18th of July, and it was paid. It was called use and occupancy because technically the tenant's right to be there ended when the 14 days ended. So the judge ordered use and occupancy to be paid by the 18th of July, and it was paid. He further ordered that henceforth, on the first of each month, the tenants would pay into their attorney's trust account the use and occupancy. And that took place for the next 3 months.
And was the use and occupancy set at the rental amount? Is that what he set it at?
He assessed that at exactly the same rental amount that had been due.
And was there any issue of warranty of habitability issues raised before Judge Edwards, or no?
Not at that time.
Okay.
However, my brother filed extensive answers, extensive discovery. In fact, he filed a motion to amend his answers and filed a motion for partial summary judgment. Oh, the third part of what the judge ordered was a pretrial conference on August 29th. When August 29th came around, no pretrial conference took place. Instead, there was an argument on the motion for partial summary judgment, which the judge took under advisement. It was a different judge.
And that had a counterclaim as related to warrant of habitability?
And other issues, yes, Your Honor. On September 10th, the judge ruled on that, denied that motion for partial summary judgment and mailed it out to the parties. Meanwhile, I had been bringing motions as well. The rent that was supposed to be, or use and occupancy that was supposed to be deposited on August 1st to my brother's trust account, I received no proof that it was deposited, and in fact, it was not deposited.
At this point in the litigation, if I could, the factual background is helpful. In this point in the litigation, if I could ask you this question. So you've got a counterclaim as it relates to warrant of habitability.
Yes, sir.
You've got a use and occupancy order. Out of fairness to the tenant, shouldn't the amount of money being ordered to be paid to the landlord be reduced by the counterclaim possible judgment, and have that money not go to the landlord, but go to an IOLTA account or to the clerk. So if the value is down $300 based on the counterclaim,
Yes.
I'm just picking a number out of the air, I'm sure it's much more than that. Well, then the tenant has to pay the landlord the use and occupancy up to the amount of the counterclaim. But when you get to the counterclaim amount, it's not fair to the tenant for that money to go to the landlord. Why shouldn't that go into the IOLTA account or go to the court?
I can tell the court that typically when we finally do have a judgment on the case, a judge will often do an actual calculation, 10% reduction for
Right.
3 months equals, and then sometimes there's two equations, and then he will come up with a final sum of what's due to the landlord. A depreciated value, if you will, of the value of the use and occupancy. So that does,
No, I know,
that it
but
does
I-
come out
but
in the
I-
final balance.
I know, but that's why I asked you in your background to stop at this point in time, because I think the arguments that you make on behalf of the landlord, which I understand, apply equally to the tenant's contention on the counterclaim, and that money shouldn't go to the landlord. I'm not saying that the landlord shouldn't get what the value of the tenancy is, as long as it's minus the amount of the counterclaim, and that shouldn't just disappear. That money should be paid into the court or into an IOLTA account. So once the judge makes his or her decision, then neither the landlord nor the tenant is out what they really were entitled to.
I agree with you, Your Honor. That would be fair. What typically happens is the landlord wants the trial as quickly as he can have it. The tenant wants a jury trial, and he wants to project it out as far as he possibly can. In this case, when we got to mid-October, I checked with the clerk's office and found that we received the notice that the motion of a partial summary judgment was denied. I found out there was no further date. There was no further pretrial date, no further date of any kind. That's when I brought the motion seeking use and occupancy to go directly to the landlord, because the landlord now hadn't been paid rent or use and occupancy for June, August, September, or October, and he was in financial dire straits.
So
Yes, Your Honor.
how should it work? I'm trying to,
Can we get to the end of the story?
okay, go ahead. Go ahead, go get the end of the story.
And then, I'm wrapped with the procedural history.
We went before a different judge, and I think what's required equitably is that there is a short, they call it an abbreviated presentation of facts and law. Well, we went before a different judge on October 31st to hear this issue, whether the tenant should be required to give use and occupancy directly to the landlord through counsel. The judge heard it, heard myself, heard my brother. We argued. I also asked for the money that was in the IOLTA account. The judge didn't even address that, but she did order that use and occupancy should be paid to the landlord each month as we progress towards a jury trial that was elected by the tenant. We received 1 month, and then my brother appealed, and all payments were suspended. So presently, the landlord has received the rent for the month of July by order, the rent for the month of November, and has not received any further funds, and he is in very financial dire straits. For a preliminary injunction, I believe there are 3 parts that are required. First, an abbreviated presentation of the facts and the law, and I would suggest that...
Are the tenants still there?
Pardon me?
Are the tenants still
They
there?
are still there. They are still in residence, yes, Your Honor. An abbreviated presentation of the facts and the law, I believe that took place on October 31st, and the judge had at her disposal at that time the complaint, the answer, the amended answer, many motions, a motion for partial summary judgment that was denied. So She had a tremendous amount of facts to review and then make her decision.
Okay, but can you,
Yes.
can I ask a question now?
The story's over, so I'm
Story-
satisfied.
I'm just trying to understand, now that I understand the story, and trying to do just what Justice Lowy was saying, which is to create a fair process and a process that has a legal support for it, what should be done? So you've got, we've got two kinds of cases. We have people who just don't pay. We also have people who don't pay because the apartments are in terrible condition. We have rich landlords and poor landlords. So what is the process and what is the legal basis for issuing one of these awards? So what should be done? You be the judge, now that you've told us the story.
If a tenant is aggrieved of the conditions of his apartment, he can, under Chapter 239, Section 8A, withhold rent, turn
Sorry,
it
what was-
over to the clerk of
What was the
courts.
statutory provision, sorry, it was what?
239, Section 8A, that's the so-called rent
Right.
withholding
Right,
statute. The old way that it was done many years ago was a clerk of courts would take that rent every month. The judge would order the clerk of courts to release these funds to either a receiver or someone in order to correct those repairs. And then when those repairs were made, the judge shall, under that statute, order the balance to be paid to the landlord. Also, the tenant can sue under Chapter 111, Section 127A through 127F. And once again, the money goes to the clerk of courts. The clerk of courts can dispense the money to have repairs done. The judge can order a receiver if he wants to. But once the repairs are done and the property is up to code, the balance of the funds shall be given to the landlord, because he's got to sustain the property and pay his mortgage, his expenses, his insurance.
You've gotten what the tenant can do. What can the landlord do? Because I take it you want to advocate for landlords being able to trigger a process to get use and occupancy, that the money goes directly to them.
I
What
think it's-
statutory, you write the decision. Say your landlord has behaved perfectly. He's not been paid. He wants use and occupancy while these battles you described go on.
Yes.
How should Judge Edwards have written that order if he didn't do it perfectly, or did he do it perfectly?
He wrote the order subject to further order of the court.
Okay, but
So the judge on the 31st of October actually was modifying an existing order.
I'm asking you to be the perfect judge and tell us how to issue that order. So tell us how to do that.
I believe that
Would you cite for that?
I believe that it is well within the equitable powers of the court to order use and occupancy. The court, when the legislature in 1980 passed the rules of summary process, they recognized that real property is very unique. And it's unique in that it generates income, and time is absolutely of the essence. To quote it, real property is unique in that it generates income, and time lost in regaining it from illegal possession can represent an irreplaceable loss to the owner.
That's Rule 1 of the summary process rules?
Pardon me?
Rule 1 of the summary process rules?
That is commentary to Rule 1 of
Right, and that's
summary
because,
process rule.
and the point of Rule 1 and the summary of Rule 1 is, the point is, it's summary.
Pardon me?
It's summary. It's supposed to be summary process
Summary is
because
supposed
of
to
the
be
value.
quick in that sense.
Right.
And this case has been anything but quick. If you notice the date today, this
Okay, but
case is.
You're going back to facts for
Okay.
a second.
Back
Just-
to the facts.
Okay, talk to law. So again, you're the perfect judge. I'm writing a decision that says the equitable powers of the court, anything you got a case or a statutory reference that you would include if you were writing the perfect decision?
I would suggest, in the rules of summary process, we're supposed to follow
Any
the rules of
particular
civil
rule?
procedure.
Any particular rule? Just-
Yes, Rule 9
Okay.
says that appointment of receivers, issuance of restraining orders, and injunctions shall be governed by applicable statutes, by Rule 65 and 66, it has to do with the appointment of receivers of the rules of civil procedure. Provided, however, that the court may modify the time periods and notice requirements of those rules and otherwise fashion the relief it orders as it deems appropriate. And that's a pretty broad brush that gives these equitable powers to a housing court judge. Actually, there's 4 courts that deal with housing court matters, but
Any good cases that we can look at, preferably ones that will have precedential value, SJC or appeals court cases?
I don't have any that indicate that a judge can give use and occupancy prior to judgment.
So do you disagree with your brother then that other statute that suggests acts as a prohibition on it?
I do disagree with my brother.
Oh, and would you explain why?
There's been a statute since 1860 that tenants at sufferance are required to pay use and occupancy in Massachusetts. And it doesn't say before judgment or after judgment. It is presently Chapter 186, Section 3. It's the most plain statute you could ever read. It's a line and a half, and that's pretty much what it says. When you're a tenant at sufferance, you are responsible to pay the reasonable value of the use of the property for the period that you remain in it.
I know it's not precedential value, but what about that District Court Appellate Division case that your brother cites?
My brother cited a case that has to do with a foreclosure eviction. This was not a foreclosure eviction. This was a rental eviction. Foreclosure eviction is very different because in a foreclosure eviction, the mortgagor, the person being foreclosed upon, is denying that the foreclosing bank has proper title, therefore they're not paying. That case is cited as same versus same, S-A-M-E, but it actually refers back to a very old case, Merrill versus Bullock, 105 Mass 489, an 1870 case, where the court tries to clarify that tenants at sufferance are required to pay use and occupancy. And it differentiates between
I think
foreclosed tenant whose mortgage is foreclosed upon and remain in the premises, or a pure rental. I call this a pure rental type of eviction.
Just to be clear, let's make sure that I understand at least what your position is. You claim that the authority of the court is equitable.
Yes, Your Honor. Yes, Your Honor.
Which means that fairness ultimately is to be the touchstone.
Yes, Your Honor.
You claim that there's entitlement to some hearing in order to address the particular circumstances of the case.
An abbreviated hearing, yes.
Okay. I think you agree that where there is a question as to whether or not the rental equals the fair value, that the entitlement would only be equitably to the fair value.
Yes, Your Honor.
So there may need to be a determination if there's rodents or other things that the rent is $1,000 a month, but I'm only going to order $800 because there are problems with the rental. So the judge would have to ascertain that as part of the equitable relief.
He might, yes, Your Honor.
And I gather you're saying that there are circumstances in which it would be appropriate for the equitable relief to go to the court or to the IOLTA account, but in some circumstances, as you say, in your case, it would be appropriate for it to be paid directly to the landlord.
Yes, Your Honor.
Is there anything else that you would say is your position?
I would just say that when a judge orders use and occupancy to go directly to the landlord, he might say, well, I'm going to give you $1,000 a month to keep your property afloat, and the balance will go into the IOLTA account. That may go either way. It doesn't have to be all or nothing. It could be a percentage.
You could split it, because it's ultimately the judge, as we said a few days ago, the village elder is sort of the person attempting to ascertain what is a fair.
Yes, Your Honor.
And that would allow the judge to distinguish between your clients, perhaps, and someone who owns 40 units, who doesn't have financial issues?
Yes, Your Honor, I thought about that a lot. I have clients that have 144 units in blocks, and it would not perhaps be irreparable to them, but it would be to a gentleman that owns one rental property. It would be tremendously difficult and devastating financially. So the judge could look at those facts, I would suggest. Thank you.
Okay, thank you.
Thank you very much.